Welcome back to The Verdict, Milnick's podcast dedicated to navigating the ever-evolving landscape of medical professional liability insurance, healthcare law, and risk management. I'm your host, Tammie Smeltz. As we continue to celebrate our 50th anniversary of serving New York's healthcare community, we're more committed than ever to bringing you timely, expert discussions designed to help you navigate challenges, learn more about Milnick's products and services, mitigate potential risks, and ultimately stay ahead in your practice. My guest today is medical malpractice defense attorney and partner at the law firm of Rubin, Paterniti Gonzalez Rizzo Kaufman, Roy Kaufman. Hi, Roy. How are you today?
Hi, Tammie. How are you?
I'm great, and I'm really excited to have you as a guest on The Verdict. Thank you for joining us.
Thank you for having me.
We're doing something a little different today. So many of our verdicts center around risk management consultants or claims reviews, claims studies, but this one we're going to talk about the medical malpractice defense attorney, and I'm really excited about that conversation. So let's start with this. What initially drew you to medical malpractice defense, and what keeps you engaged in this area of law?
Well, let me break that up separately. In terms of how I got into this field, I started out as a hospital administrator. My dad died when I was very young, and my mother went back to school and she took a job as a secretary to the executive director at Brookdale Hospital. So as a young boy, I would take the bus after school and meet her at the hospital, and I had the free reins of Brookdale Hospital back in the mid-60s, and I was just enthralled by it. And it was the reason why I pursued a career in management, and that led me to graduate school where I got my master's degree in hospital administration. And I thought I wanted to be a hospital administrator until one day I had a class called Legal and Ethical Issues in Healthcare. And I was mesmerized by it. It was a professor, he's long since gone, named Harold Hirsch, who was both a JD, MD. And back in the 70s, this was right after Roe v. Wade and the Karen Ann Quinlan case and the right to die issues. And there was so much happening that it just enthralled me. So I decided to apply for law school. And I got into law school. And one day I'm looking on the placement boards and I saw an advertisement. I went to St. John's and I saw a position for a full-time clerk at what was the premier medical malpractice defense firm in the state, Martin, Clearwater, and Bell. And I got a job as a docket clerk, not knowing that really meant I was a male clerk. So I was probably the only male clerk who ever had a master's degree in hospital administration, but it was the best opportunity I ever had. It was great.
Well, thank you for sharing that with us. And, we see a lot of nurse attorneys and there are some MDJDs, but never in somebody with a background in hospital administration. So I love that. What better defense for our doctors and our hospitals than somebody with that background? And I'll just say, if you ever want, a second job or a side gig, I'm sure we could use you here at Milnick because we do have a lot of hospital insureds. So let's take a little step back. What keeps you engaged right now in the area of law? Because you've been practicing for quite some time, correct?
Right. Well, it's my 45th year doing both medical malpractice, defense, and claims, because I have had some career moves over the years. Once I became an attorney, I decided that the best way to get experience was to teach. So I taught at St. John's in the undergraduate program there, same course Dr. Hirsch taught, legal and ethical issues in healthcare. And it was great because I got up in front of small groups that turned out to be the same size as jury selection voir dire panels. And I got comfortable on my feet. And it was just a fascinating experience. I ended up teaching at St. John's for about 20 years and also at State University of New York at Stony Brook, teaching a graduate school course and a summer course. What keeps me engaged and Rewarding? Well, the engaged part is the fact that as a lawyer, you're constantly learning. And that's really what I love about the law. I had a mentor more than 40 years ago who explained to me the difference between a job and a profession. And what he said to me was, when you're in a profession, every day you must learn something. That's the main difference. So I've kind of always remembered that. What do I find rewarding? Paying it forward. So teaching younger attorneys, mentoring, that's what keeps me still doing this.
That's great. And our focus today are the younger attorneys and mentoring. So we'll get to that in a little bit. And I know we're only doing this via audio. Nobody is actually seeing us, but I can't believe you've been practicing 45 years when you only look 50. So you must have started at a very young age, or you take very good care of yourself.
Tammie, I may not have heard you so well. You may have to repeat that a bit louder because I only got part of it. No, I'm just kidding. Thank you.
Okay, so talking about medical malpractice defense, what does a day or a week look like in your profession?
The best part of it is that every week is different, that you're not doing the same thing every day. And part of that has to do with the medicine itself. That tomorrow I'm conferencing a doctor on a colorectal surgery case. Last week, I ended the week with a pediatric case. Toward the end of this week, I have a matter involving ophthalmology. And while that might look daunting, that there's three separate, medical specialties, I find it interesting and challenging. Um, I'm obviously no expert in any of those fields, but I learn enough to have a conversation. And my job is to be the legal part of the team, not the physician. I'm not expected to know, nor do I know what a physician knows, but I know the things they don't know. What happens in a courtroom, what happens during a trial, and my job is to make the clients feel comfortable and at ease. So that's also pretty rewarding.
Yes, I would imagine. And I think, I worked at a law firm for a while before I came to Milmick. I worked as a legal nurse consultant. And even though you said the lawyers aren't really the medical experts per se, which they're not, I was always in awe of how much medicine attorneys know, and especially at the time of trial. It's amazing to me. And as you said, every case is different. There's different specialties. And then as time goes on, the standard of care changes. So you have to learn, new procedures or new ways of do things in the field of medicine. So it is that constant learning process, right?
Can I tell you a secret?
Yes.
Uh, I forget everything right after a trial. So I might know the medicine cold for a 2 week period of time, and then I may not have a case with the same medicine for 6 months to a year. I've got to relearn it again.
And I guess that would make sense, right? And plus, you're trying so many cases, I don't know how you could possibly remember all that information. So let's talk about the younger attorneys. So this was what we really wanted to talk about today. Throughout New York, I guess we are a little bit concerned that we may have a shortage of medical malpractice defense attorneys in the future. What opportunities what opportunities are around for young attorneys to get significant responsibility or engagement early in their career?
So part of that question really asks, how did this come about, this podcast, this initiative? So I'll dial the story back a little bit. A few months ago, Melnick Insurance Company and MedPro Group had their defense counsel in for one of the regular meetings. And one of the topics of conversation is how to develop the next generation of trial attorneys. And thanks to Mike Shopman and Bob Ryan and Tim Krieg, they put together this initiative where they're asking the defense counsel and the defense industry to work with them to bring up the next generation of trial lawyers. It's starting in the law schools, and the insurance companies are meeting with them to advise young lawyers of the opportunities that are out there. And then they get a buy-in from the law firms themselves, which are who are willing to go out and hire new lawyers and train them. And most importantly, a word we're going to talk about a lot, mentoring those lawyers. Because, boy, no one is as good as the teacher they had. It's just the way it is. So I'm very excited about what's ahead. In terms of the opportunities, just about every law firm on the MedPro MLMIC panel is committed to hiring and training the next generation of lawyers. And we're excited about that.
That's great. And we even have a program going. I believe it's called the Rising Stars,
Yes.
where we're kind of mentoring and honoring and meeting with some of these younger attorneys to kind of mold them to follow along in your footsteps over the next few years. So what are some common misconceptions that younger attorneys might have about medical malpractice litigation?
I think the most common one is that the medicine is too hard to learn, or that since they don't have any medical background or scientific background, it's impossible for them to learn to get on that level where they could be comfortable. And I have to say that given today's technologies and what's available out there, the tools, that's just not the case. So when I went to graduate school for hospital administration, we took a course in yeah, basically medical terminology, and we learned the difference between root words, prefixes, and suffixes. So you learn very soon that ectomy means removal of, and when you put it after the word appendix, it becomes appendectomy, and it's removal of an appendix. And when you do it that way, medicine gets pretty simple to at least understand on a global level. If you started asking me about cellular changes and the scientific basis, or how do these Ozempic drugs work, I have no clue. Okay. But I can take a tutorial on the internet. I can look at a video. I can see how an operation is performed. And then with the help of experts, which MLMIC and MedPro give us, and we appreciate that, we work with our clients to form a defense. So I think the first part is that the medicine is not that challenging, that you learn it and you get comfortable with it. The other misconception, I think, is that physicians are difficult clients. And I've grown the whole spectrum because I started in my late 20s and I'm now almost 70. And I'm looking at this and I'm going, what do clients really want? They want a lawyer who is responsive to them. If I return calls the same day, if I answer emails the same day, if I respond to texts, the clients know they have someone there for them. And that establishes a relationship that's almost unbreakable right from the start. Uh, you learn that clients are looking for emotional support because this is the first time in their life where someone is saying they did something wrong. They're used to getting A's on tests, and when they're sued for malpractice, they're devastated by it. So just understanding the perspective of the client goes a long way. I hope I answered your question.
Yeah, no, you did, and I agree with everything. I mean, I remember, in my days, some physicians being so distraught in tears, and it really is an emotional experience for them. So part of it is defending the case and knowing the medicine, but also being by their side, answering questions, being responsive, and just holding their hand, when they need it, when they need a little extra attention. Going back to the medicine, I totally agree that, it's not as hard as it you would think it is. But when you are a newer attorney or a younger attorney, would they start off trying a case where maybe the medicine is more simple or more routine, like a failure to diagnose MI or a cholecystectomy, like something where you see that scenario a lot in litigation and might be a little easier to understand. Would a younger associate start off trying that type of case, or do you throw them right right into the complicated, some of the complicated, like for me, it was always anesthesia, right? Anesthesia and also ophthalmology. I think you mentioned that earlier. Those two types of cases are always, I feel, trickier.
So associates generally don't try cases by themselves without some type of uh, significant experience. And what I mean by that is, and that's what I enjoy about the initiative that MLMIC and MedPro are doing, which is they're allowing lawyers to second seat senior experienced counsel. And that's like a great thing for the older lawyer because we have someone with us who knows not only the technology, but they understand that the analogies that I used 40 years ago don't hold up anymore, and that I've got to get more current. And having a younger set of eyes seeing the same thing I'm seeing is beneficial to the older attorney, and the younger attorney is seeing something they never appreciated. If you don't mind me going on a rant for a minute or two, I am forever beholden to the law school that I went to. They gave me a phenomenal legal education. Uh, I was fortunate enough to pass the bar exam on the first try because that's what that school did, and they did it well. But law schools also have a long way to go. They don't teach young lawyers the business of law. So they come out just the way physicians come out of medical school, not understanding what a RVU unit is and how that drives revenue. And a young lawyer doesn't understand billable hours and how law firms make money. Uh, but more importantly, law schools don't teach the actual practice of law. That you only find in a courtroom or in a deposition or in a lawyer's office. And you know, having worked in a law firm, that the paralegals, the paraprofessional staff know so much more than young lawyers coming out of school. So the best thing a young lawyer can do is ask questions. Remember, I told you I was a mail clerk? I tortured everyone in that office with questions that to this day they probably still remember. What's an index number? How does it get assigned? When does it get assigned? And then my questions got a lot better. What's the difference between an interrogatory and a bill of particulars? Okay. When would you take a deposition on oral questions versus written questions? What do you do when a client is dying? And that's what I was talking about before in terms of it's a profession where you could learn something every day. So hope that answered the question.
Yes, and I love what you said about that because it's all about mentoring and learning from a team approach, right? It's the entire law firm. It is not just the senior partners or the partners, it's everybody that works on the case together. So it's collaborative. And the younger attorneys shouldn't worry about what they don't know when they go into the office practice because they have a whole team of people to help them from lots of different aspects,
Well
which is
said.
which is great, right? Now listeners always like to hear war stories or just any type of story. So I was wondering if you had an example of a time when an associate attorney on your team made a significant contribution to one of your cases.
Sure. So before COVID, I tried a case involving colorectal surgery where um, one of the attorneys in the office um, did the plaintiff's deposition for me. And the case involved a sphincterotomy gone awry that had a poor outcome, an accepted complication, but a poor outcome. And the case was tried. The attorney who did the plaintiff's deposition did such a phenomenal job of setting up the case where it was obvious to the jury that the patient needed this procedure. Not only was it indicated, they really had no choice, that the patient understood the risks, and she started to delve into the employment background of the patient, um, how smart he was, how he supervised others. So he couldn't take the position that he didn't understand what the physician was saying. And she did such a marvelous job that we ended up with a defendant's verdict. And I immediately called her up and told her. And then when we publicized the verdict, we put her name with my name on the top because it really was a joint effort that produced that result. So that's just one example.
That's great. And just out of curiosity, where is she today? Is she still practicing law? Is she still with your firm?
She is still with our firm, but
Aw.
she is now a managing partner in the firm.
See, that's great. So that's another reason why, it's good to take that chance on med mal, start young, have a good mentor, learn the process, and then you can become a partner. So going back to your firm specifically, how does your firm or the field in general support the professional development and mentorship of younger attorneys? I know we touched on that. We have the second chair, we have deposition prep, but are there any other mechanisms that law firms or your law firm has to support these younger folks?
So I think our firm is a lot like a lot of other firms these days. We have structured programs. Um, it's really necessary in order to get the proper training. And let me distinguish between a supervising partner and a mentor. So to me, a supervising partner is someone who just monitors performance. That might be someone who signs off on a report or does an employee evaluation at the end of a year. But to me, as a mentor, is someone who knows you personally, who understands your strengths and your weaknesses, and uses them in a fashion that they know will work best for you. And a dirty little secret is that people need to have more than one mentor, sometimes at the same time, sometimes many during their lifetimes. And just someone who will look after you, someone who will give you that career guidance that not necessarily is best for the firm, but best for you. And that's what we're trying to do at our firm these days. We have a group of about 6 or 7 younger lawyers. When I say younger, I mean less than 5 years out of school. We have 2 partners, Christina Papadopoulos and Rob Castillo, who meet with these younger lawyers at least once a week in a formal setting where they go over a specific topic. What do we write to the carrier and what don't we write to the carrier? That's a big ethical issue. Okay. You don't want to provide information that obviously impacts attorney-client privilege. You want to make sure you don't take a client out of coverage by reporting something that's not necessary. So little things like that need to be taught because you're never going to know that from law school. So as part of this presentation that they do once a week, they also present a case where a senior attorney would present a case that's going to be coming up for trial, and then they roundtable it. And you get great perspectives from younger people. And you'd be shocked, or maybe you wouldn't be shocked if you've been on a jury lately, that jurors are younger and younger than they ever were, and that they have different ways of evaluating cases. We were taught to listen because we had no visual aids back then. Now, most jurors, they don't rely on their ears, they want to see it. So if you're talking about a medical record, they want it blown up on a screen so they could read the words themselves. So this younger generation also tells us what's effective and what's not effective. I think it works great.
Yeah, that is great. So you kind of learn with each other as you go on, right?
Yes.
Now, what advice would you give a young attorney who is on the fence about specializing in med mal?
Well, the same advice I give to all law students. First thing is find out what you don't want to do. Okay. Which is for me, I touched one matrimonial case in my life. That was enough for me to know I don't want to do that. Okay. Um, but if you think you might have an interest in criminal law, see if you can volunteer in a district attorney's office or at legal aid and find out if that's something that you want to do. In MedMal, there are opportunities that insurance companies have, and just about every insurance company has like an apprentice program, not only for lawyers, but also in claims. And a lot of claims departments are hiring attorneys because of the great analytical skills that they come out of school with. Uh, so there are some really good opportunities. So my first point is know what you don't want to do. And there's a real important reason for that. Can you get pigeonholed in your career? Yes, you can. Okay. Because once you've got 5 or 10 years of experience in one field, it's kind of hard to transition over to another field. So it's important to do something that you like. That's you want to go to work doing something that you enjoy.
That's for sure, right? And you want it to be a profession, not a job, as you said earlier, so that, I feel the same way about that. Like I learn every day, and that just makes your profession or your career much more enjoyable.
I can give you another piece of advice that was given to me years ago, and it still holds true. You don't need a formal internship. Courthouses are open to the public. If you're a law student, walk over to the closest courthouse to where you work or you live and go ask a court officer, you have any trials going on? You have any med mal trials going on? Which parts? Just go in and sit in the back of the room. You learn more from what people do poorly. I love watching trials. And the reason I do is I see what works and I see what doesn't work. And you can create your own path by doing a lot on your own these days.
That's for sure. And I think earlier you said that you don't want to get pigeonholed into like a certain specialty of law. How many years do you think it takes to really decide whether you want to be in med mal or you want to be in criminal? Like let's say like you're just a newer attorney, you've been out maybe a year. Like how long should you spend in one specialty area before if you don't love it, when should you move on?
It's a great question and a difficult one to answer, which is what you always hear when people try to punt, right? But here's the challenge. In today's day and age, lawyers can make more money by changing jobs than staying in the same job. Okay. And what we saw, especially during COVID, is lawyers moving around every 12 to 18 months uh, for a raise. But the problem is when your salary is significantly more than your skill set, your career is doomed because you're going to hit a plateau where you're making money that people say doesn't match your skills. I can't afford to pay you that because you only do this. Whereas if your skill set is constantly increasing, then you have opportunities galore. Um, how long does it take to know that? You can tell early on. It's usually the environment you're in and not the field. What I mean for that is if you have one of those jobs where the people you work with only value you for your billable hour, you're in the wrong spot. Okay. If, on the other hand, they are invested in you, not just financially, but personally, that's a place you need to stay.
Okay, that makes sense. Now, looking ahead, what do you see as the future of medical malpractice litigation, and what role will younger attorneys play in that future?
See, if I knew the answer to that question, I'd play the stock market and I'd be so rich that I could retire tomorrow, but I don't. I'm still trying to figure out how artificial intelligence is going to affect our field in the next few months, let alone few years. I see it being used by everyone, experts, lawyers who draft reports. I'm old school. I still type mine out because I edit it as I go. But I go back to the early 1980s where lawyers dictated to legal secretaries who took stenography. Uh, and then we had no computers, so it was like corrected type when you made a mistake and tissue carbon papers. Um, so in terms of what's ahead, they will never replace the analytical skills that lawyers have because what lawyers do well or should do well is they should listen better than other people and they should observe better than other people. And as well as you can teach a computer a large language model, I think that's what that is for OpenAI or one of those,
Yeah.
you can't read body language off a piece of paper. You can't read people's reactions, verbal and nonverbal reactions to testimony. That just comes with experience. So I do think that every time there's a challenge, and AI is a challenge, there are going to be opportunities from it. But the reality is the med mal field has dozens upon dozens of senior trial lawyers in their 60s and 70s who are going to retire, hopefully, in the next 5 to 10 years. And that is going to create more and more opportunities for younger lawyers. And that's what I'm excited about.
Yeah, I agree. I mean, I think we see that all over New York State, that we have a lot of trial attorneys who are, as you said, in their 60s and 70s, and that will open up some opportunity for the younger folks to move up and, become managing partners or senior litigators at their firm. When you mentioned AI and other learning mechanisms, now as opposed to years ago, which I do, I did do shorthand in high school, and I remember those days when all those things happened. So I guess we're really dating ourselves. But even if you learn from AI or some other kind of like trendy mechanism, you still need communication skills as a lawyer, right? You have to go in front of the judge, in front of the jury, and you have to communicate all that you learn through AI or whatever and make people understand it. So there's still a human aspect to the trial lawyer, even if you do learn some other way,
And
right?
for young lawyers, most of their assignments, and that's the beauty of med-mal, is if you went to work for a white shoe firm, I'm not sure they're called that anymore, they'd have you buried in an office, paying you a ton of money, just indexing transcripts. Whereas our attorneys, as soon as they are admitted, they go to court. Now, sometimes in the beginning, it's just to argue a simple motion, or it might be to, you know, deal with a discovery issue. But you learn skills on your feet. You learn how to de-escalate people. You learn how to get what you need through compromise and also, being a good, kind person. When we used the term profession before, um, lawyers used to take care of their own, not cover up for things that were terrible, but I'm just saying support each other in a way where it always wasn't adversarial. And if you look at a lot of older lawyers, we're friends. We can argue with each other in a courtroom, but we'll go out as friends afterwards. And that's what I find particularly rewarding.
And that's one of the things that I really enjoyed when I worked at a law firm. And even when I worked in claims at Milmick, we would go out, defense attorneys and the plaintiff's attorneys would be there, and everybody would be friends after a trial. Maybe there was one or two plaintiff's attorneys that weren't friendly, but the majority of them, we all had a great relationship with. And that really says something about the practice of law in New York, right?
It does, although it's sometimes discomforting to our clients when they see us friendly with someone who is suing them. Um, but the ones who know that we put our heart and soul into their defense and will do nothing at all to ever jeopardize that. So I think it all works out.
Okay, so before we say goodbye, if a young attorney wants to contact you, or maybe even, I'm going to say a college student interested in law, or maybe even a high school student interested in law, how could they reach you?
They can go on to the firm website, Rubin Paterniti, which is like rpgrklaw.com. They could contact me directly from the website. It has my contact information. Or for a more structured program, they can contact our managing partner, Christina Papadopoulos.
Okay, great. Thank you. And do you have any last advice before we say goodbye? Any advice for our listeners?
Well, anyone that's really interested in the program that MLM and MedPro have put together, I'm going to refer them to Mike Shopman, and I'll probably hear from him that I probably shouldn't have. He'll probably get a lot of phone calls and emails from that, but he's a good friend, so I know he will point people in the right direction.
He certainly will. And talk about a good mentor, right?
Yes.
Yes. All right. Well, thanks, Roy, for being a guest on The Verdict today. It really was my pleasure. I enjoyed speaking with you, and I hope we can chat again sometime in the future.
Anytime. Thank you.
And that's The Verdict with Roy Kaufman, exploring the intricate world of medical malpractice defense. Attorneys interested in the field of medical malpractice defense can reach out to Roy at 516-340-1083 or email him at Kaufman, Kaufman, at rpgrklaw.com. Thanks, everyone, for joining us today. I hope you enjoyed this very informative podcast. Stay connected with us on Facebook, LinkedIn, Instagram, and X for updates on our new podcast. This podcast is for general purposes only and should not be construed as medical or legal advice. This podcast is not comprehensive and does not cover all possible factual circumstances. Because the facts applicable to your situation may vary, or the laws applicable in your jurisdiction may differ, please contact your attorney or other professional advisors for any questions related to legal, medical, or professional obligations, the applicable state or federal laws, or other professional questions.